So let's start with the definition then of what is integrated estate planning. May very well depend who you ask, of course. My definition is it's the result of the marriage between traditional estate planning and lifetime asset protection planning. Traditional estate planning tends to focus on what happens when somebody dies. It's a bit of a narrow focus. Should it be, or is it that in all cases? No, but it is a bit of a narrow focus that focuses on what happens when somebody says goodbye. The lifetime side of the integrated estate plan to me is making sure that we have an estate at death time, so we have an estate to which that fancy estate plan can apply to. So the result of the marriage between traditional estate planning and lifetime asset protection planning. So I speak in terms of then the lifetime asset protection component of integrated estate planning as being the process of organizing one's assets and affairs in advance so as to preserve the estate in view of risks to which the estate is subject. We have the box below. IEPT stands for Integrated Estate Planning Trust. Again, we're integrating the lifetime asset protection component with the death time typical traditional estate plan. And I'm illustrating around the box that these sorts of strategies that we're talking about, and then the issues we're talking about in terms of staying on the right side of the law, can apply to really just about every type of asset. Obvious things like stocks, bonds, liquid assets, real estate, etc. Perhaps things, too, that don't quite come to mind so readily, such as interest in a business, life insurance proceeds, jewelry, art, antiques. A couple of key things in the definition here. So, process of organizing one's assets and affairs in advance. Who wants to help out here? In advance of what? In advance of you getting your retainer check? In advance of, what did you say, I'm sorry?
Taxable events?
In advance of taxable events. Well, I'll take a minute and do a sidebar here, thank you. I'm skipping ahead just a little bit, but typically this sort of planning, at least as done for Americans, is tax neutral. And I will develop that for you a little bit farther into my speech. So I myself am not too concerned about taxable events for the typical American client. Now that may be uninteresting to many of you if you have a tax practice, but as you've seen from other sessions, you might be needing to think about where that tax practice is going in today's environment. So what we have been doing out of my office for 25 years out of little old Denver, Colorado, is simply tax neutral planning designed to, I should say income tax neutral planning designed to protect assets during life, and then upon death incorporate all the gift and estate tax things we normally can do. So in advance of, not to belabor the point, but in advance of, notice that something's going on from the litigation standpoint, because it's in the client's interest and it's in your interest as an advisor to avoid anything that has to do with this concept of fraudulent transfers or assisting with making fraudulent transfers. In other words, the client really needs to do this planning at a point in time when probably the client is least inclined to do it, which is when the seas are calm. Just like fire insurance, it has to be taken out before there's the fire, before the match is struck, before somebody even comes across the matches or knows that there's going to be somehow a fire. It needs to be done as a preventative measure. Let's call it a vaccine, not a cure. If somebody's been bitten by the bug already, it might be too late to do any planning. Or at least it'll be too late to do as much planning as the client would like to do. There may still be things you can do, but probably not as much as the client would like to do. So in advance, to be developed, so as to preserve the estate in view of risks to which the assets are subject. Most Americans approach this from the standpoint of the biggest risk they're concerned with is the litigation risk, which is probably no news to you. People in other countries might be motivated by other issues or concerns, political strife, social unrest, the local economy, things of this nature. For the typical American, it's going to be the litigation risk. So we've talked about what this is. Equally important to talk about what this is not. As you can see up here, it's written it must be true. It's not an excuse to evade or even avoid income taxes. Now, we know that tax avoidance is legal, although in today's environment, one would still wonder. We know that evasion is not legal. So clients will be confused if we're talking with them about going offshore, if we're talking with them about going to places like the Cook Islands for asset protection purposes. Many will immediately jump to the thought or idea that, well, there must be a tax benefit here. And one way to get on the wrong side of the law is to sell it as a tax benefit and implement it as a tax benefit for, reasons that we've talked about throughout this conference so far for a day and a half. So how can we go offshore and make sure that we're not doing this as some form of tax evasion? Well, what's the cure for preventing, or what's the vaccine for preventing tax evasion? Yes. We have a volunteer at the back. She says, pay your taxes. Disclose and pay your taxes. And in particular with a structure like this, I'm going to talk to you about how when we have a trust that's settled by an American resident or citizen that's offshore, number one, it can still be a domestic trust for tax purposes. Number two, it'll still be a grantor trust for tax purposes. And number three, it can be funded with, I like the B word, $1 billion. Right? Offshore isn't what it used to be. $1 billion's not what it used to be, but still. Fund it with $1 billion and pay absolutely no gift tax. But you say, wait a minute, Engel, you said that, well, no. We're not going to have to pay a gift tax. It'll still be in the estate when the individual dies later. Now, if the client wants to get it out of the estate for estate tax purposes, we can still do that. Yes, that's a different type of planning. No particular tricks involved, just normal old estate planning focusing on lifetime transfers and that sort of a thing. But we can fund it without regard to, let's put it in context, you're telling the client, the good news is I can protect your $50 million estate. The bad news is you're going to have to pay a transfer tax of $20 million while you're alive. How many clients would you have? 0. But the regulations work with us in this context and allow us to do our funding but not pay tax, but in essence defer the tax until death. And that comes in very handy. So I'm not here to talk about an excuse or a rationale to evade or avoid taxes. The planning that we do is not based on hiding assets, another way to stay on the right side of the law. We're not hiding things. We're not putting together a plan, and I have a model plan for you, by the way, that I'll walk through. We're not putting together a plan that falls apart as soon as the client is under oath and on the stand, in which case either the client has to tell the truth and the secrecy-based plan falls apart, or the client lies so as not to disclose, in which case risking, what's it called? Perjury. And all of a sudden, perhaps a civil matter, a fight over money, turns into a fight over criminal charges and indeed one's personal freedom. So this is not based on hiding assets. Now, obtaining privacy for a client is another matter. Privacy versus secrecy, two different approaches. Clients appreciate the fact that they can get some privacy out of this sort of a planning approach. But privacy is much different than secrecy, because secrecy, again, when you support the secrecy to promote the plan, you're risking criminal implications. That's not the case with simply a privacy-based approach, which in essence says privacy might be the first wall, but if somebody happens to discover through public records that the LLC that owns it is managed by me as the manager, well, that's okay. That's not the end of the plan. That's kind of just the beginning. And then next, as I've indicated, not a justification for fraudulent transfers. You'll see I have some random pictures just to keep it more interesting, so if you start to drift away from my words, you can think about like Florence, Italy, or some such place. Or my dog. Foundations of the asset protection component of the integrated estate planning process. It's a very basic concept. Property is either more or less protected depending on how it's titled. So if property is in an individual's own name, let's say they have $1 million managed account or brokerage account. It's in their own name, they're sued, they lose, and the account isn't exempt as, say, an IRA or a qualified plan or some such, the account is as good as gone. If the property was in a U.S. state-based family limited partnership with a state with favorable laws or an LLC, if they were sued and they lose, the money is not necessarily gone. It's the beginning of a fight, and the client has a little bit of leverage. And leverage is always good when there's litigation. If that $1 million account was in a trust that was in one of the states that has a domestic version of the offshore trust law, which started in 1997 with Alaska, and today, depending how you characterize, we have 15 states that have law that mirrors what you can do offshore. It can only go so far, but at least it's good to have it because it gives it credibility, if nothing else. A third of the states or so have the same sort of thing. If it was in a domestic trust, then it would be all the more difficult for somebody to obtain access. And finally, if it's in a foreign asset protection trust, all the more difficult for reasons I'll explain. So one of the foundations is property is either more or less vulnerable to creditors depending on how it's titled. So my point to you is part of what we do, part of what you may do if you do this work or if you decide to go into this work, is simply look at a client's balance sheet, see how things are held, and see how the exposure risk can be improved by changing how it's titled, how property is titled. Here's a question. Let's say, talking about staying on the right side of the law, and that's not necessarily, by the way, the criminal law. As you know, there's a couple types of law: administrative, civil, criminal, ethical. And as a lawyer, you can be, if you do it wrong, as a CPA, if you do it wrong, whether you're in this country or out of this country, you can be found criminally liable for your actions. You can have civil exposure to the parties. You can be in trouble with your ethics board and disbarred. What are CPAs when they're kicked out? They're not disbarred. I don't know. This isn't a joke. This is a question. I don't know what the term is. Delicensed? I don't know. Delicensed? Okay. So you can have that happen to you. But you don't want any of those to happen to you. So what happens if you are an estate planner and somebody comes to you and they've got a nice estate and you do your planning, and again, you want to avoid malpractice in what you do, and you do your planning nicely and you do a very nice estate plan, and then 3 years later that client is sued because of some event that happened just a couple months earlier, and then 2 years later the bulk of their estate is dissipated. Question. Staying on the right side of things and avoid being sued. Do you think they have a claim against you for possibly malpractice, for not either doing some asset protection techniques or for not at least specifically eliminating that sort of thing from the scope of your engagement, in your engagement letter? Interesting question. So some lawyers don't like the concept, but the question is, if the technology is available and you could have done something when they come in to talk to you about estate planning, and after all, isn't preserving the estate one of the estate planning goals? Preserve it from probate, from taxes to the extent we legitimately can, and so on. Well, if the technology was there and you didn't at least raise it for the client's consideration, I think there's a claim there. So again, staying on the right side of the law, the civil law, in terms of at least let the client know that some things can be done that would improve the situation in case they happen to be on the wrong side of the litigation fence. The second principle, in general, creditors can only collect against what one owns, not what one formerly owned. Client has that same $1 million investment, the brokerage account, the managed account, I think I said. They take that money and they contribute it to an irrevocable trust that then turns around and buys a very large single premium pay life insurance policy. And then 3 years later, the client is sued, 2 years after that, they lose, and the creditor would like to go get that $1 million policy. What do you think their chances are going to be? Any thoughts? We're assuming away any sort of fraudulent transfer. You're shaking your heads, either meaning I'm not making any sense, or meaning possibly the creditor is not going to have much of a chance. And I'll go with the second of my two options. And that's the case. Why? Because the client used to own it. They gave it away legitimately, put it into a legitimate trust. They didn't do it with the intention to hinder, delay, or defraud a creditor. They didn't do it at a time when they were insolvent, which is another type of a fraudulent transfer. And throughout my talk, keep in mind that it's the ownership of property that gives rise to its exposure to one's claimants and creditors. So no problem. So if somebody has no interest in property and they have a judgment, an adversary can't get at that property. If somebody today owns property but severs the ownership link by way of giving it to children, giving it to a spouse, giving it to a charity, giving it to trustees of a trust, the ownership link is severed, and once again, keep in mind it's the ownership of assets that gives rise to their exposure to claims and creditors. So part of what we will do is simply, and yes, I get paid for this, help clients divest themselves of assets. There's actually a living that can be made doing that. Help clients divest themselves of assets. Maybe it's outright to a child, maybe it's outright to a spouse, but more than likely it's through a trust vehicle that's designed flexibly so that they can retain not complete control, but certain elements of control. Certainly not complete benefits, but certain elements of benefit. So when it's all said and done, they're not the owner, but they can have a trust set up for the benefit of the family through which they have certain elements of benefit that are left and control that are retained. Just how much in any given case, obviously, is just a matter of how it's designed. There are a number of tools in the toolbox. I've put them on a ladder here for your knowledge. I've put them on this ladder in terms of good, better, best scale of efficacy, starting with just outright gift giving, joint ownership of property, exemptions, the foreign annuity, liability insurance. To me, these are the good tools. Going up the ladder, limited partnerships, domestic, and LLCs, of course, domestic integrated estate planning trust, the hybrid company, the foundation or civil law foundation, the better tools, and then, to me, the best at the top, the foreign situs integrated estate planning trust, and then probably the granddaddy of them all, expatriation. Now, in my experience, a number of clients have expressed interest in expatriating, but not a lot of them have really ultimately done it. But other lawyers have a different perspective on that. That's my perspective. So I'm not going to talk about expatriation today because it isn't a far and wide reaching concept for clients. It's not something if a physician who offices downtown comes to talk to you about asset protection planning, perhaps she's in her mid-30s, a thriving practice, couple of children, family's been in the U.S. for hundreds of years. I guess we can say that now because we've been around for at least 200 years. Talking about expatriating is probably going to fall on deaf ears. So we talk about the next best thing on the ladder, the integrated estate planning trust. Any given plan is going to involve a mix of these tools. Now, what's missing from the ladder and why? Well, I've already addressed, at least in brief for you, secrecy and hiding assets. I've already referenced going offshore for income tax advantages. That's not what we're doing. Disclaimers. I mean, if somebody's being sued and their aunt in Des Moines, Iowa just passed away and left them $1 million account, it might be possible for them to disclaim an interest in that property and have it pass as if they had predeceased the deceased aunt. That's a possible technique, depending on whether the state determines that sort of thing to be a fraudulent transfer or not. In some states it is, in some states it's not. But if a client comes in with a balance sheet and says, here's what I have, help me protect it, you can't really talk in terms of disclaimers. So it's not on the ladder. Same thing with retirement plans. They have certain protection because they're exempt from creditor reach under both federal and state law. But if a client comes in with that balance sheet, you're not really able to say, let's drop everything into a retirement plan. It'd be nice if it worked that way, but it doesn't. And then finally, corporations, whether domestic, foreign, or bearer shares. Well, we might have corporations in the plan, but they're not really something that we use when we create a plan. And the reason is, when somebody forms a corporation, they're really exchanging asset for asset, aren't they? They're taking the initial assets that are funded into the company in exchange for stock. And the stock is exposed to creditors. So they might turn around and gift the stock to children or gift it in trust, but that's not relying on the corporate form for the protection. That's relying on the A, gift, and the B, fact that it went into a trust. Now, I also say here, too, that we're not using the concept of bearer shares that I'm sure many of you are familiar with, because that's a concept that relies on secrecy to work. Nobody will ever know that I have those shares. And that's not the approach that we want to take with this sort of planning. So these sorts of tools that in your mind have some asset protection elements to them, you may say, well, why weren't they on the ladder? And that's my answer. I have this slide because, at least in my experience, if you ask 5 lawyers for a definition of a trust, you'll get 8 answers, and even then, many of them will hem and haw. So let's just kind of set the foundation, the groundwork for the basic concepts behind the trust. It's an English concept. It's not found in every jurisdiction. So civil law jurisdictions will tend not to have or recognize the concept of the trust. Key to the trust is it separates legal title and beneficial title. So Anthony Will from Cook Islands Trustees Limit is in the front here, and he might be a trustee, and so I give property to Anthony here to hold for my children in his capacity as trustee. He, or his company more particularly, has legal title to the property. The beneficiaries have beneficial or equitable title. So a trust involves splitting title to property, and the interesting aspect here is, in the civil law, as a few of my civil law colleagues have responded, the concept of dividing title is repugnant to their legal system. They say, you can't divide title. Well, you English common law people are crazy. I said, well, we can. That's why we use Anthony, because he can help us divide title. But here's the point. Remember, it's ownership of property that is the exposure for the property. So the question is, and you can help me answer it, when I create a trust, I put property in trust for trustees to hold for the benefit of beneficiaries, who owns the trust property? The trustees do. Who owns the trust? Well, if I form a corporation, I get shares back, I'm the shareholder. If I form an LLC, I put assets in, I get back member interest, I'm the member. If I form a trust, the grantor. The grantor is the grantor is the grantor, but not the owner, because you don't get back the certificate of ownership in a trust, say. Trustees own it for the benefit. So nobody, that's the key point, and thank you. Nobody owns a trust. There's no owner of a trust. There's owner of trust property for beneficiaries, but nobody owns the trust. In fact, Americans tend to think of trusts as entities, and I think the tax law kind of forces us into that because we file returns for trusts. So we think, but they're not entities. They're really an arrangement. They're really a contract that carries third-party, beneficial, and fiduciary duties on the part of the fiduciaries. So they're really a third-party beneficiary contract with fiduciary duties. You can have an oral trust. If you're interested, my office charges just half as much for oral trusts. That's a pretty good line, guys. Come on. Think about it. All right. Tough crowd you got to work, Anthony. You can have an oral trust. Obviously better to have it in writing. But it's that writing, that's that written contract, that's the third-party beneficiary contract that carries with it the fiduciary duties. That's what a trust involves. Key point here is, when it comes to the trust, nobody owns the trust, which is one of the reasons why it works in concept so well for asset protection. Now, there's a couple of reasons why, we can stay onshore or we can go offshore for asset protection. I've got a couple of the reasons listed here. There's a couple of key ones. One isn't listed. One key one is, if a client is concerned about the American system, and I'm not saying it's good or bad or right or wrong, I'm just saying clients have concerns, so let's address them. If a client's concerned about the American system, how much sense does it make to turn to the American system for protection if they want asset protection? To me, it makes no sense, but, some people do it. We prefer to go offshore. One of the main reasons we prefer to go offshore is comity issues favor foreign trusts. That's the idea of whether or not the judgment rendered in the U.S. is going to be any good in that foreign jurisdiction. We don't want it to be any good if we're asset protection oriented. We don't want there to be comity. But as between, say, Florida and Nevada, there's comity, and that's because there's something in the Constitution called the Comity Clause, which says states will give full faith and credit to judgments and court orders rendered in other courts and other states and so on. So right there, we kind of knock half of the wind out of the sails of the asset protection sailboat. Second, avoidance of issues concerning federal law preempting state trust law. What I'm getting at here is the principle of law is federal law is superior to state law. And state law trust law is just that, so what if it's the federal government that one day is the claimant? Well, it might turn out well, it might not, but we don't know much about that yet. But these are two very key reasons why, to me, it makes more sense to go offshore in the planning. Another reason that I list here is the increased ability of the settlor to retain those elements of benefit and control. Another reason, the foreign trust is less likely to be an automatic target in litigation against the settlor, which I have seen in a number of claim situations. Finally, the foreign trust will, just as a matter of fact, be more protective, so that's very important. So the importance of proper timing for the asset protection component and staying on the right side of that civil law consideration. I don't mean civil law as in types of legal systems, I mean civil law as in civil lawsuits. Few little words to keep in mind: pending, threatened, or expected. If the client has something pending, if the client has something threatened, or even just expected, right? The surgeon who comes and says, well, I'm here to see you because it seems to make sense to me to do this sort of planning, and by the way, I haven't been able to find my favorite orange sponge. I don't know where I left it. I've been traveling lately, and is something expected there? Well, maybe. So that puts you on notice. And the hallmark of a fraudulent transfer is a transfer made with the intent to hinder or delay or defraud creditors. Hinder or delay. Either one of those is enough. So something I hear from counsel who call me, we do a lot of co-counsel work with lawyers in other states, and they're bringing their cases to us. Sometimes we can take them, sometimes we can't. And I hear this one a lot. Can't we just do something so the client increases his leverage? Can't we do something so we can just buy some time for the client? Not hinder or delay or defraud. Now, what's your downside as an advisor? That's part of what I'm going to be talking about in just a minute as I get through this foundational work here. Certainly, if there are outstanding judgments, we want our collective antennae to go up. And then through more little words, as I've referenced, civil, criminal, and ethical exposure. How much will a client put into their planning structure? Some clients want to take what we call a nest egg approach, slice a little bit of the estate off, stick it aside so if something happens one day it's protected. Other clients will want to put in toto. And the question or the concern here is if they put in too much, even though they didn't have a fraudulent intention, it might be what's called a constructively fraudulent transfer. And a constructively fraudulent transfer basically is one where somebody makes transfers of property and they leave themselves with too few assets. Now, the interesting thing here is that a lot of my clients start out thinking they have too few assets already, as do probably most of us. So I don't know what too few assets means, but that's how the fraudulent transfer law works. It says if you make transfers and you make yourself insolvent or with too little, given your station in life and your profession and your risk profile, then that would be a constructively fraudulent transfer, which is a fraudulent transfer by definition, de facto, without regard to intent. So the less you put in, the less of a risk that is. The less you put in, the less is protected, and the less you put in, the less interesting it is for clients. And so, there is a balancing that has to be done in this regard. Now, let's walk through the model that I promised you to give you an idea of what we're talking about, and then I want to turn to some of the specifics about the criminal exposure and civil law principles that apply in civil liability. Let's start out with the idea that a client has, let's go back to that $1 million managed account. The client's goal is to protect that. Maybe the client has a $5 million net worth, maybe the client has a $50 million net worth, but to facilitate our discussion, just assume there's a $1 million managed account, and the goal is to place that into a planning structure. Typically, and this is just a model, so typically, we'll start out with a family limited partnership. And the FLP is an interesting vehicle, as are most LLCs, because through this process, we can take an attractive asset and turn it into an unattractive asset. If the $1 million is in the individual's own name, it's exposed. Well, we can get some leverage simply by changing that apple into a lemon and converting it to an interest in the LP. So the money goes into the FLP, and out comes a 1% interest to the client as the 1% general partner, and out comes a 99% interest to the client as the 99% limited partner. Now, I know you can't be in partnership with yourself, but there's an easy fix for that, either through a straw person or through the spouse participating, so we have two partners. But the concept, and again, I'm simplifying here to facilitate the discussion, the concept is once that $1 million goes in, what does the client now own? The client doesn't own the brokerage account. The client owns interests in the partnership that owns the brokerage account. And a creditor's remedy, should the creditor one day have a judgment against that partner, the creditor's remedy is to get what is called a charging order. And a charging order is in essence a lien on the partnership interest. It doesn't permit, importantly, doesn't permit the creditor to liquidate the entity. It doesn't permit the creditor to force a distribution from the entity. All it does is it tells the creditor, sit back and wait, so if money comes out one day, you're the first to get it. Well, that's better than losing the assets. It's not as good as other remedies to the creditor, and it's not as favorable as other approaches for the debtor. But the idea is we can force this waiting game so the property isn't immediately lost. And if the creditor doesn't have a reasonably foreseeable chance of being paid, we probably have some leverage in getting that judgment settled. And in the meantime, Revenue Ruling 77-137 tells us that the income from the partnership is going to flow through to the creditor as the economic successor in interest of the partnership interest. So a creditor who gets a charging order runs the risk of being taxed on the income of the partnership, whether or not the creditor ever becomes a partner or ever receives a penny. And that's helpful when it comes time to try to negotiate out of a legal issue. Step 2, we'll create the trust with the foreign trustee, often a domestic trustee, a trust protector off to the side here, and then beneficiaries. Usually it's family members that are beneficiaries. We have a U.S.-based domestic trustee as the kind of liaison between the family and the structure, and then we have the foreign trustee, which is a trustee company in the selected jurisdiction. connect them together, we simply transfer that 99% limited partnership interest to the trust. Easy enough. Now, staying on the right side of the law tax-wise, we need to file and we need to pay the tax. This is a grantor trust. That means all the income flows through. It's either a grantor trust because of certain powers or interests retained, or it's a grantor trust under Code Section 679 that says all foreign trusts are grantor trusts and taxable to the grantor. So the income tax side is easy. Everything flows through, pay tax on it. Gift tax implications. Well, when the gift is made, which is the transfer of the 99% interest up to the trust, when that gift is made, because of powers of appointment that are retained over the trust by the grantor, Treasury Regulations 25.2511-2B and C tell us, 25.2511-2B and C, tell us that that's an incomplete gift for gift tax purposes. Meaning for gift tax purposes, it's as if it didn't happen, but nicely enough, for state law purposes and debtor-creditor relations and things like this, it did happen. And how can that be? Simply different tests under different bodies of law. The gift tax law has this concept of an incomplete gift, which means it's only completed when the property goes out to a third party as a distribution or when the individual grantor dies. That's when the gift is completed. Then the assets are in the estate and they're taxed under the estate tax. So as far as income tax principles, this is very much a tax-neutral plan. Where you become non-tax neutral is when you try to play games. So disclose if there's a foreign bank account, which there need not necessarily be, but if there is a foreign bank account, the TDF 9022.1 needs to be filed by June 30. The partnership each year is going to flow the income up to the trust and then out to the grantor as a grantor trust. So there's a K1 that's going to go out to the grantor, and the 1040 is going to have all of that information. Gift tax return, well, we suggest it be filed even though it's an incomplete gift. Actually, one part of the regs say, in that case, a gift tax return should be filed, and another part of the regs say a gift tax return must be filed. But we also like the gift tax return as evidence in court if there's a civil claim one day that a gift was in fact made. I mean, you never know what's going to resonate with a judge, and one thing that might be critical to a judge is he may say, well, let's see, well, aren't you required to file a gift tax return on a $1 million transfer? And it'd be nice to say, well, yes, here they are. See, a gift was made. Again, you never know what's going to resonate. So when it's said and done, our structure would look like this as an integrated estate plan, a last will that pours the residual of the estate over to the trust, and then in many cases assets are held under the family limited partnership, can also of course be held directly under the trust. Now, let's talk about another side of the law, contempt of court, principle of contempt of court. What happens when a judge tells your client, there's a judgment that's outstanding, it hasn't been paid, I know there's money offshore, bring it back by next Tuesday or you're going to jail. Anybody ever had that happen to them or a client before? Okay, well, I have. I'm happy to say that no client has ever gone to jail for contempt of court. You know, maybe other stuff, but never for contempt of court. And that's what we're talking about here today. And here's why. Well, let's set the stage for this unhappy result. One of the remedies, if there's a threat one day, is to force the battle over trust assets into the foreign court. So if funds are held in that underlying limited partnership, as a protective measure, the foreign trustee can step in and fire the domestic trustee. The trust protector may or may not stay on, but the important point is the foreign trustee then can liquidate the partnership and 99% of the assets are upstream to the trust. And I've already advised, avoid fraudulent transfers. Is that a fraudulent transfer? No. The answer comes because it's not the debtor, the settlor, scrambling at the last minute to make asset transfers. It's the trustees who, in fact, have a duty to protect assets, and in fact, if they don't do something protective, may themselves be sued for wasting trust assets. It's the trustees saying, you guys fight it out amongst yourselves. We're going to take our basketball and go home because we don't want to be part of this game. And then if the adversary wants to go sue the trustees in the Cook Islands, which has happened a time or two, not often, but a time or two or three, they can certainly do that. So the money is now sitting in one or two or three offshore banks under the umbrella of the trust, and the judge says to the client, bring it back by Tuesday or you're going to jail. What do you tell your client? Right, we're talking about staying on the right side of the law. I think implicit in that is obeying court orders and playing according to Hoyle. You tell your client to comply. And hopefully your client listens to your advice and does what he can to bring assets back. But let me go back to an analogy I used earlier, and the analogy is the $1 million is placed in an irrevocable life insurance trust, and a big fat policy is bought. Now, if a client sets up an irrevocable life insurance trust a couple of years ago, and then today goes to the trustee and says, you know, give me that money back, what do you think the trustee is going to do? What he should do, basically nicely say, go pound sand, or in so many words. Well, same thing here. I mean, the difference is if somebody has the power to cause something to happen and they don't comply with the court order, they can be found in contempt of court. If somebody does not have the power, then the impossibility of performance defense to a contempt of court charge comes up. And that basically says if you don't have the power to comply, you can't be held in contempt of court. So that's the exception. Now, like any other good body of law, as you know, there's an exception to the exception. The exception to the exception is, but if you made it impossible yourself, you can't avail yourself of the impossibility of performance defense, the self-created impossibility. So where does that leave the client? Well, you have to look at the cases and see just exactly, of course, what that means. Think about it in practical terms. You today have a box of papers that you destroy. A year later, you're sued on that transaction, you know, what was in the box, and a year after that, you're compelled to produce all your files, and you say, well, you know, I was cleaning out my garage and I threw a bunch of stuff. Well, can you be held in contempt of court because you can't produce that box of papers that you threw out a couple years earlier? No. And it's because there has to be a nexus or a link in time and intention between what you did to create the impossibility and the specific court order. So in our case, creating a structure doesn't mean we can't one day, if we have to, take advantage of the impossibility of performance defense. Even if somebody does planning right in the face of a problem, there's a Supreme Court of the U.S. type case that says that's not a close enough nexus. What we're really talking about is a specific court order and then something you do that makes it impossible for you to then perform. So, staying on the right side of the law when it comes to contempt, simple advice, do what the man in the black robe says. Always good advice to follow. Let me go now to there's another tax and compliance issue, of course, to mention, and that relates to FATCA. And final regulations were issued in January. You might take a look at those. And by the way, I do have an outline it's a rather thorough outline. It's about 78 pages, 200 if you want pictures of my family vacation, but just text's about 78 pages. And if you want that, just email me and I'll be happy to PDF it to you. This is the first year I've done this program and I wasn't quite sure what the protocol was on when it came to handing out outlines. But I'm at b.engel@engelreiman.com. Engel is E-N-G-E-L, and Engel Reiman is E-N-G-E-L-R-E-I-M-A-N. So just let me know, and I'll be happy to get this to you. And the final regs under FATCA and the new draft forms that have recently been issued by the IRS on things like FFI compliance and the like, these things are discussed in the outline. If I had a morning to talk with you, we could go through that. Let me now turn to a couple of different ways that, if we're staying on the right side of the law, we want to be aware of that claims can come at us. And by the way, in the U.S. system, it might not be enough to just ultimately win a case. We'd like to say here, once you've been sued, you've lost. I think it's nice to kind of keep your nose clean and do things right so that you avoid the number of times you're going to be sued in the U.S. system. We were sued in a case, my firm, a couple years ago. We were out on a motion to dismiss about a year and a half after the claim was filed for some of these things that I'm going to be talking to you about here now. And the federal court in New York said, there is no liability here, motion to dismiss. So that means, we never even had to file an answer to the complaint that was filed against us. But just to get to that stage was about $600,000 in defense fees. So, aside from the mental cost and everything else. So it's just a good idea, I think, to err on the side of caution so that you just don't subject yourselves to these sorts of things. But of course, in any type of practice, you have exposure and you have risk, and hopefully you have your own asset protection plan to help protect against something disastrous happening. And as we saw with our own asset protection plans in place, i.e. my partners and me, it helped to bring the matter to a quicker conclusion with some of the lingering issues that remain following the motion to dismiss being granted. So one type of claim that a practitioner could be subject to is, of course, malpractice. Not only for doing it wrong, but also maybe for not doing it at all, as I've alluded to. Another risk might be a defective plan. The plan didn't work for some reason. An aiding and abetting claim. Now, interestingly enough, well, just to use the case, my case was in New York, and that was fortunate. Our case, I should say, it was the firm. And it's fortunate because aiding and abetting is something that's very well developed in New York and is actually very difficult to have a plaintiff prevail on if they're making claims based on aiding and abetting a fraudulent transfer or something like this. Or conspiracy to commit a fraudulent transfer is another type of claim that can be brought. And New York has some very call it protective law that says, there's really no claim at the end of the day for assisting somebody in making a fraudulent transfer. That's New York law. I've got some of the cases in my outline that stand for that proposition. Or if you're going to be held liable, you actually have to have some personal benefit at the other day beyond just merely making some fees for representing somebody. You really have to have been involved, and you have to really have a financial stake in the thing to be a co-conspirator. But that's New York, and that's more or less kind of Florida as well. But that's not all the states. If that same case was brought in my home state of Colorado, our law says, you're hanging out, baby. There would have been a different result. Different tests, different standards of the law, different precedent. It varies state by state. So while I was unfortunate to have my firm sued in New York, aside from things like back then $850 per hour for the lawyer, today over $1,000. Of course, the lawyer said to me when we were looking at other lawyers, he says, I'm twice as expensive, but it's going to take me half the time. And you know what? He was right, and the fellow that we had at Loeb & Loeb was excellent, if you ever need a referral. But he was twice as expensive, but it did take him half the time. And they didn't have 18 associates all over the case day in and day out, which was also kind of nice. So kudos to them. So the point is, it depends where the suit is brought, and it depends on, obviously, the facts of the case, but co-conspiracy or aider and abetter of a fraudulent transfer or aider and abetter of breach of fiduciary duties, these are some of the things that can be tossed at you if you're on the other side of a case. And I would tell you that no client's case is worth the possibility of inheriting. As much as you might want to help somebody, or as much as you think, oh, this is a bogus case, and there's no way that the system would ever find liability here, you're not judge and jury. The first thing a litigator, if you get sued and you go to a litigator, and you say to your litigator, gee, doc, what are my chances, how long I got, or the legal equivalent thereof, they're going to say, I don't know, it's unpredictable. The jury system is completely unpredictable. That's true. You never know what's going to happen. So if somebody comes into you with a good story and you're convinced that there shouldn't be any liability when all's said and done, you're still taking a chance if somehow a jury happened to disagree with you. All right, criminal statutes that you should be aware of course. There's a number of states that make a fraudulent transfer either a misdemeanor or a state felony matter. Most states do not. Fraudulent transfer is a remedy statute. And by the way, I'll make the point, fraud and fraudulent transfer are much different animals. It should actually be called an avoidable transfer rather than a fraudulent transfer. But, over the years, the term fraudulent transfer has developed. I mean, one key difference is fraud involves reliance to somebody's detriment. And when somebody has somebody coming after them because of an auto accident and they make transfers at the last minute to their children, there's no detrimental reliance. I mean, there's some key differences between fraud and fraudulent transfer, and the cases say that. But I'll tell you that to an ethics board who you're trying to defend your actions to over your license, I've seen that, not in a case I've ever been involved in, but I've seen that fall on deaf ears because courts hear the F word in fraudulent transfer. And that's all they need to hear. They don't care about the fine points of distinction. So at the state level, making a fraudulent transfer can be a misdemeanor crime. It might be a felony crime. Under the bankruptcy code in the United States, we have some extensive provisions dealing with what are called bankruptcy crimes. Now, a client is absolutely not exposed to any bankruptcy crimes statute unless they happen to file bankruptcy or be forced into an involuntary bankruptcy. And over 25 years of doing this sort of work, we've had really only a very few handful of clients ever go into bankruptcy. It's just not the normal course. Usually it's one matter that blows up, they've got one battlefield to fight on, and it's one claim, or multiple claims under one situation. But a client can still end up in bankruptcy, and you don't want to have to defend yourself against fraudulent transfer in the bankruptcy court, against hiding assets in the bankruptcy court proceedings, against being a co-party in the bankruptcy court proceedings. Also, the anti-money laundering provisions, the Money Laundering Control Act in the United States, have a number of provisions that deal with, financial crimes. And some other crimes are considered then to be money laundering predicate offenses. A bankruptcy crime, for example, might also then carry money laundering offenses. So even though asset protection has little to do in the typical sense of then what is money laundering and what is that out there to combat, getting this wrong can lead to charges under the anti-money laundering provisions. Mail fraud and wire fraud as a crime in the United States. Again, we want to stay here on the right side of the law. There's a famous case where a lawyer sent out a couple of bills. And if you can believe it, the lawyer had some phony entries on the bills. Anybody ever hear of anything like that before? No hands, absolutely no hands. Okay, well, it happened. I see your hand down there. Yes, thank you. And I've received some of those from lawyers too. Thank you. Because I've had to hire them over the years. Anyway, without any political or social commentary, back to the case, the lawyer sent out some phony bills, and the lawyer got hung for mail fraud. Now, who would ever think that somebody doctoring or padding their time on a bill is something that could end up as mail fraud in the federal system? But it just shows you the breadth of that. So, criminally speaking, if you're involved in an asset protection plan in the wrong setting and things are being mailed or wired, funds or correspondence, certainly it's possible. My outline has a couple cases on mail and wire fraud. Criminal RICO as well. RICO is designed to go after patterns of racketeering. First of all, racketeering is defined very broadly. Mail fraud, wire fraud. Any act indictable under the Currency and Foreign Transactions Reporting Act, which has relevance when we're doing asset protection planning. And you know what a pattern is, according to RICO? A pattern is 2 times in 10 years. That's a pattern. Obviously, we have provisions, as by the way I work toward wrapping up, we have provisions governing tax crimes, conspiracy to defraud the United States if the U.S. happens to be the claimant, misprision of felony, and then crimes described in the Federal Debt Collection Procedures Act. So what I've set out to do in my short time frame today is give you an overview of asset protection planning, asset protection trusts, foreign versus domestic, and the wisdom of going offshore, and then various areas where you could find yourself that you kind of wish you hadn't found yourself. So for example, fraudulent transfer area, tax compliance area, civil, criminal, and ethical areas. Do it right, be careful, keep your files documented. It's a great area to practice in. Get it wrong or get too wrapped around the axle on your client's affairs and deals and expose yourself, the result can be quite traumatic and expensive. Any questions I can answer for you? Sir?
In terms of international jurisdictions, which ones do you favor for such trusts and why?
I like the Cook Island statutes because I wrote it, along with 2 others. We were invited by the Cook Islands in 1989 to draft the first of its kind asset protection specific legislation. And it was kind of an interesting exercise because we were doing this work using the Isle of Man at the time, and it really gave my law partner then and I, and then the New Zealand barrister that invited us in this effort, gave us a chance to sit back and say, okay, so where are the holes in what we're doing using the Isle of Man, and how can we patch those statutorily? And it was kind of fun. And I think today we've seen not only that it has the most thorough and protective law, but that it also has among the best trustees qualified to do this sort of work, because there are many, so you need both. You need the good law and you need the trustee company. And I've seen other trustee companies that are very happy to take the annual fee for acting as trustee, but as soon as the finger is pointed at them, they buckle. And that's not what you want to have happen. So you need a trustee that can stick out its chest and thump it, and you also need a jurisdiction with good, protective, thorough law to support the concept. All right, anything else? Thank you. Yes?
The conspiracy to defraud the United States, I've seen them use that broadly, claiming they were concealing, trying to cover something up as you're going along. They claim that they're entitled to know things, and that by preventing them from knowing things, that's conspiracy to defraud them. I guess also, we were talking about the reports that you're required to file. I've seen where there's more than one that wasn't filed, sometimes they'll throw that onto the indictment also.
Right.
They're claiming they were entitled to have that information, and you defrauded them of the information.
Well, I guess I'll repeat the essence of what you say for the tape. I think if the government is your adversary, first of all, they've got unlimited resources, they've got all sorts of statutory provisions they can throw in, and sure, they're going to throw in 55 counts, and you might end up settling for one count of, conspiracy to interfere with the judicial system. Sure, of course, but, we all do it. I mean, if I'm sending a demand letter to an adversary saying, this happened to my client, and they suffered this, and they said, I'm going to start out with, I demand $55 million in cash delivered to my office tomorrow, and then maybe we'll get some money one day. I mean, I'm exaggerating, but you can expect that, absolutely. You can expect the overcharging, as you put it.
And after the Anderson case, has there been any more significant developments in this area?
Yes, quite a few. The comment was, after the Anderson case, have there been any more significant developments in this area? And the Anderson case, for those of you that don't know, is probably the first real challenge to one of these sorts of things that involved the settlors of the trust actually going to jail for contempt of court. And the mistake that the Andersons made was they set in motion what made it impossible for them to perform after they were ordered to repatriate assets. So, of course, they were held in contempt of court. But it's the first case that people tend to bring up when they say, oh, gee, I thought this concept died with the Anderson case. Well, no, in fact, it's very much alive. And since Anderson, there's probably been another 10 or 12 cases of note. I've written extensively on the concept of does this work and so on and so on, and I have some of that in my outline that I can send off to you. I'll just mention to you in terms of does this work, the frame of reference is it's not an absolute victory or not. What we're looking for is when it's all said and done, did the client come out better than the client otherwise would have had there been no planning in place? I mean, that's the realistic goal. And in every case where the client followed protocol and we were involved in the challenge, we met and surpassed that goal, and I've had over 100 challenges over the years. That's a big number. It's a small percentage of cases. It's probably 8% or so of the plans we've done, but that 8% translates into over 100 challenges, and that's where the rubber meets the road in this work. Not when somebody says, here's your asset protection trust, thank you very much, where's my fee? It's when 3 years later they call and say, I got a problem, who should I talk with? That's where the rubber meets the road. And the standard there is, when it's all said and done, did they come out better than they otherwise would have by at least a moderate level or degree? I think we're overdue. Thank you for your kind attention, ladies and gentlemen. I enjoyed talking with you. Thank you.